Well, Chair of the Justice Committee, Paul Givan, joins us now. Thanks for coming into the programme. We've had this announcement today, but is there a danger of political interference in something which should really be a judicial matter?
Well, ultimately, it's the politicians that set the legal framework in which the judiciary have to operate. Quite rightly, politicians should never interfere in individual decision making. That's a matter for the judges, but we, the politicians, represent the people, and ultimately we are the guarantors of the rule of law. And if we feel that the legislation isn't adequate, then we can change that and we can set up a framework in which judges can then operate.
You wanted to see this happen, but clearly if a review, once it's carried out, it doesn't necessarily mean that the sentences will go up.
No, but the clear intent that we have highlighted is the sentence for this individual case of the murder of Constable Carroll is not sufficient. We're outside the normal parameters that operate in England and Wales and indeed the Republic of Ireland, and we want to be brought into line at least with the rest of the United Kingdom, and indeed others would suggest that when you commit murder of a police officer, life should mean life. And this review I welcome. It allows the opportunity for us to change the way in which the system operates and show that actually devolution means something to people, that actually we can be effective in this place.
What about Jim Allister's point today that why do this now? Is there a difference between the murder of a police officer now compared to during the Troubles?
Well, the difference of course now is that policing and justice has been devolved. We can't answer for the way in which direct rule ministers operated the system, but we can now change the system because we have the power in our hands. Now let's allow the Court of Appeal to review this sentence, and then let's look at whether or not we believe that the current framework where the judiciary can review the guidelines is working. And if it's not, then the politicians can look at that, and that's where David Ford has said he'll review this following the Court of Appeal's decision, and then let's establish a framework that everybody can sign up to.
Would you like to see the English system brought in here?
Well, I don't believe 30 years is enough. I believe whenever you kill a police officer that represents the front line of democracy on behalf of our society, that life should mean life. Now that's my starting point. Obviously there's a need to build consensus around all of this, and we'll engage in that review. We'll seek to build that consensus and have something in place that will deter those terrorists that want to kill our police officers. Recently they're attacking them, and we need to have a framework in place, as Lord Justice Givan even said, that reflects the changes and the needs of our society today.
What about the distinction of young people then? In England they do make a distinction and say that people under the age of 18 should receive a lesser sentence.
Well, again, this is where the judge needs to, in my view, have the flexibility that if a young person, if they're below the age of 18, demonstrate the craft and guile of someone that's over the age of 18, that have the mental capacity of someone over the age of 18, then the pure status of what their age should be isn't something, in my view, that should be taken into account. If they're able to commit this crime, they should be able to do the time.
Thanks very much for joining us tonight.